In August, it will appear.
My lords, in 804, I'm requesting for listing. My lords, I have filed my additional documents. It was directed to be listed after 1 week once the additional documents are
15th
filed.
May is the date being
I filed
shown.
it.
15th May.
Obliged, my lords.
Your Lordships, may I mention the Indian Railways matter in which your Lordships had delivered the judgment on 8th of May last week. Your Lordships, I was appearing on behalf of respondent number 13, Grid Co. I was being led by my senior Mr. Sanjay Sen and briefing counsel Mr. Odijit Moitro. Your Lordships, the submissions of respondent number 13 and the appearances are not reflecting.
So what do you mean to say?
Your Lordships, I'm just requesting if the appearances and submissions may be recorded.
So
Your
now you will
Lordships.
rewrite the judgment.
No, Your Lordships, it's in our favor. Only Mr. Sen had advanced his arguments. It was recorded by your Lordships also.
Write all submissions.
No, Your Lordships, it's just a request, Your
Let's
Lordships.
be happy.
Your Lordships, at
Will
least
record your appearance.
This kind of request I'm hearing for the first time.
your Lordships, you filed the note also. It was not. Okay, Your Lordships.
Yes, I'll clarify. I didn't find any substance in it.
Your Lordships, the appearances
No, I'm
may
sorry.
be
Yes,
appearances may
that's
be
a
recorded,
genuine
Your
request.
Lordships. Grateful,
Appearance
Your
will be
Lordships. Grateful, Your Lordships.
appearance क्यों नहीं दिखा?
Your Lordships, will hand over the appearances again.
My lords, may I kindly mention an after notice matter? My lords, this was mentioned in a listed mentioning. Yes, my lords. My lord, I'm saying this is an after notice matter because, my lords, it was stayed in May of 25. We had moved a listed mentioning last month, my lords. But the person who was supposed to mention, there was a medical emergency in their house. My lords, that's why now the matter has been directed to be listed in July. There is some urgency, my lords, may be listed this side of the vacation on any day convenient, my lords. My lords, there is another proceeding pending between the parties, my lords, where they're
The list.
relying on the stay.
All
My
on
lords,
the
they are-
list.
May I please, my Lord?
I'm great.
My Lord, on the last date of hearing,
Lord, I'm appearing for the
Lordship has
number 2.
directed me to find out whether the learned single judge who had decided the matter had the roster or not, my Lord.
Yes.
My Lord, we have placed on record the, my Lord, roster of the High Court, my Lord.
Had the determination.
No, my- yes, my Lord.
Why do you say so?
Lord,
Please come to page 3 of your counter, of the counter filed by the Uttar Pradesh government.
Lord, I don't have the counter, my Lord.
You don't have the
No,
counter.
my Lord.
We have already supplied advance.
What is
copy,
this?
that's why only.
It has been placed on record.
We have.
We must have emailed to the AO.
You must have been served. Otherwise, how could it be part of the record?
Lord,
So don't forget about that. Because it can be heard by either by Honorable Saurav Lavania J or by Honorable Rajiv Singh J.
no, my Lord, I have placed on record the constitutional bench, my Lord. My Lord, in fact, my Lord, may kindly have my additional
Can
document.
you
my Lord.
please give your counter?
Yes.
And please come to, this is not paginated. This is not paginated. You come to annexure R1.
Yes, my Lord.
R1 page 3. R1 page 3.
Yes, my Lord.
Right. Now see serial number 13, Honorable Lavania J.
Yes, my Lord.
He has determination in respect of all major bail applications. Right? Now come to Honorable Rajiv Singh J.
Yes, my Lord.
Number 3, all criminal matters not provided elsewhere. So this is not a bail application under 482.
Yes, my Lord. Lord,
This is a suspension of sentence matter.
Yes, my Lord.
And you will not find in this list
No, my Lord.
that
it is there.
anybody else has been given suspension of sentence.
My Lord, the,
So it comes within number 3.
my Lord, the criminal appeals, my Lord. My
No,
Lord,
it's not
kindly have-
criminal appeal is separate. This is an application under 389.
my Lord,
There is some ambiguity here. If there is an ambiguity, we will rule in favor of the learned judge who has taken up the matter. Argue on merits.
please, my Lord.
I'm the aspirant respond number 2. I need to file counter. My lord.
Lord, it's a cold-blooded murder, my
Lord,
Lord. My
I-
Lord. 5
You are entering appearance today.
No, my lord.
He appeared, my lords, on the
But I could not file, my lord. My
No, but office report says that nobody has entered appearance.
Lord, he was on caveat.
He was on
I was on
caveat.
caveat, my lord.
He
File
appeared.
your counter. 2 weeks for counter, 1 week for rejoinder in the week commencing 20th July. We have heard learned counsel for the parties on the question as to whether the learned judge who passed the order impugned, had the determination to hear the application for suspension of sentence under Section 389 CRPC. Having looked into the documents, we are satisfied that the learned judge did have the determination. The objection of the petitioner to this effect stands overruled. Uske baad counter.
May I please, my lords? My lords, I am in custody, my lords, for 4 years and 4.5 months now. And my lords, all the four co-accused.
NPS matter.
Yes, my lords. All 4 accused have been granted bail, my lords. And my lords, out of total 25, only 6 witnesses have been examined.
You were traveling in the truck
Yes, my lords. I was the cleaner, my
and you made an abortive attempt to flee.
No, my lords.
Thereafter,
I was apprehended at
after
custody.
you were apprehended there,
Yes, my lords.
right? 6 have been examined out of 25.
Yes, my lords. And my lords, 4.5 years, my lords, I have undergone.
You are for the other side.
Please, my lords, I'm for this.
Have the co-accused been granted bail?
4 of them, my lords.
I'll have to get instructions on that. This is in advance service,
My
ma'am.
lords, we have annexed the orders also, page 55, page 57, and page 60. 4 co-accused, all of them have been released on bail.
The driver has been granted bail.
No, my lords, driver expired during the trial.
So who are the 4 who have been
My lords,
granted?
according to the police, they were the suppliers of. I was the cleaner. I was, my lords, only 20 years old. My lords, I was only 20 years old.
Very well. You file your counter.
Obliged.
Notice counter.
Quantity is too much.
My lords, may I have it this side of the.
No.
Obliged, lords.
Anticipate. The respondent number 2 participate actively in forging the power of attorney, and due to that power of attorney, my lord, kind of consider, my lord, even my lord in revenue
Grant of bail, we are very.
even in revenue entries, my lord, my letter has been forged, my lord.
Court has granted bail, we will take away the liberty. In a 420, 467 case.
My lord, this
We
observation
could
made by-
understand if it's a
Yes, my lord.
murder case. Not in a 420, 467 magistrate travel.
Whatever the observation should not come in my way in the trial, my lord.
Of course, it is for the purpose of disposal of the bail application.
Maybe observe, my lord.
No, nothing more.
I am deeply.
Yes.
Milord, the respondent should not comply their own letter, Milord. Kindly see on page number 63, Milord. In 1986, the petitioner should be the deputy commissioner, Milord. Kindly page number 63, Milord. The junior of the petitioner become the deputy commandant in 20th of August 1986, Milord.
The single bench holds that in a contempt petition, you are canvassing the issue of your compulsory retirement.
Yes, Milord.
Why?
Milord, in 1980.
Why? That has certain finality with the order of the Supreme
Yes,
Court.
Milord, we agree, Milord, but there was the order of the.
Which order has not been complied with? Which order of the court? Don't show any departmental order.
Yes, Milord.
Show us that this is the contempt.
Single bench of the single
Which
bench
page?
of the Calcutta High Court on page
Which
number
page?
117. Concern portion
117.
117.
117.
Starts
Come to 117.
115, Milord.
The single judge has been so sympathetic to your cause. Para 15 has directed disbursement of all amounts, right? Calculated from September 96 to February 2019.
Kindly see the second
Right.
para.
And
Second para.
your-
Kindly see the second para, Milord.
There is only one error committed by the division bench. Division bench says that intra-court appeal is not maintainable. That is erroneous finding.
Milord,
But the appeal has not been dismissed only on that ground.
Milord, for a moment, see second para on page number 117, Milord.
Sir, what's your age, sir?
It means plan age.
85.
He got everything. What is this?
Although we are not,
As per your own letter, he should be the deputy commissioner
although
of
we do not agree with
1986.
the
Milord.
finding of the division bench of the High Court that the intra-court appeal against the order passed by the land single judge disposing of the contempt petition was not maintainable is incorrect, having regard to the decision of this court in Midnapur Cooperative So-and-so Bank versus Chunilal Nando. The division bench is right in observing that the order of the single judge dated 13 September 2019 did not merit any interference having regard to the indulgence shown by the land single judge. No reason to interfere, dismissed.
My lords, this is statutory appeal under Section 22 of the NGT Act. In this matter, my lords, my review application has been dismissed by the NGT after finding
Right.
that they don't have the power. My lords, may I just show the proof?
There's a platform I constructed so
Yes.
that people
My
don't
lords,
drown.
without any provision, without any permissions, my lords, in CRZ one
When the platform
area.
is removed, there will be flooding.
My lords, that's
What is the size
only
of the platform, madam?
4.5 into 10, my lords.
What is-
I understand, my lords, but this is done in a CRZ one area, an
Please don't,
ecologically sensitive
convert
area.
these matters into ego issues, right?
My lords,
If
see,
something has been done,
my lords,
assuming without permission,
my lords.
but there is a finding given by two authorities that it is ultimately benefiting the public, why should the authority?
My lords, the finding is on the basis of a site inspection report not approved by GCCDMA, my lords.
Dismissed.
My lords may just see the site inspection report on the basis of
Next
which
matter, madam.
I'm grateful.
It's the Honorable High Court literally has said that so far as OBCs are concerned, there should not be any time limit for the.
No. Why did you curtail the window?
Let's the.
Why did you curtail the window? Is it
Window was-
possible? Is it possible today? Today you say that you need to bring certificates between, say, 1st of April to 15th of May. Suddenly, in the midst, you say that no, the window period is curtailed by 20 days.
No,
It will be within 15.
not in the missed millets.
No.
In the
that is
advertisement
there.
itself. The advertisement itself, millets having been issued.
There's a larger issue involved in this case. You want to crush the career of OBC people on a technical ground.
No, millets.
No, there's no finding
That they do not belong to us.
that don't belong to OBC category.
Let's kindly consider.
Please.
Where is that finding? There is no finding. You are only saying that your certificate was not obtained within the
Window provided.
window provided.
Lordship, let's.
They are OBC candidates.
Let's out of 500 candidates who applied.
No, please.
Maybe some were fortunate, but we also know how government officers proceed.
Let's, would your lordships
Huh?
consider?
Unfortunately, these 42 people may be faced with officers
Would your lordships?
who would not act without silver.
Would your lordships consider only one thing, let's.
Tell.
Ram Kumar Gijroya.
Let
Let the
No,
question.
Milord, just one.
Having regard to
Let
the
the question
peculiar
of-
facts and circumstances.
Question of law may be
Let
left
respond.
open.
Having regard to
Milord, I was on caveat. My caveat expired. Just one submission. Though my lords are dismissing it. My lord, for
Who are you,
2000,
sir?
for 2020.
No,
you are the candidate.
Yes, my lord.
You are the candidate.
No. My lord, I was a lawyer in the High Court also. I filed
You are-
caveat
Who are you
for the
representing?
petitioner, respondent, my lords.
So candidate.
Yes, candidate.
So if you are dismissing the matter,
No.
where is your right of audience
No.
as a caveator?
No. I just wanted to make one fair submission. my
No,
lord.
please don't make
I'll-
it. It's okay.
Having regard to the peculiar facts and circumstances noted by the division bench of the High Court, we see no reason to interfere with the impugned judgment and the special petition stands dismissed.
But the question of law with regard to the cutoff, whether.
Peculiar facts and circumstances, we have said.
My lord, I apologize.
Grateful.
Please don't open your mouth when the court is with you.
No.
You may be extremely fair, but we don't require your fairness now.
My lord, next.
Because it may so happen that what you think is fair could turn to your disadvantage. Right? We are very strange people. We can take views, we can change views very abruptly.
That's a fair.
Especially both of us.
That's a fair.
In number of cases when the caveator stated something, we have issued notice because he stated something contrary to the record and contrary to our thought process.
I'll not intend to.
Right? Yes.
Grateful.
Thank
Grateful.
you.
Yes, my lords.
What else is, what do you want, sir?
Well,
Speaking
sir-
order has been passed.
No, my lords, it was not, it was directly.
Sir,
Yes,
only error that we find in the order is instead of the date 27th October 25, it should read 13 January 26.
Right, my lords. This is one. And my lords,
Challenge that order of 13 July, January, we will clarify that.
my lords, because it was also directed to preserve the CCTV camera.
They
But-
say that
but-
because of monkeys in the
Yes, my
area,
lords.
we don't have that CCTV.
But this is a false statement by the.
You are mistaken.
Yes.
Come to my house. More than 100 monkeys, they are daily in my house.
But my lords,
No. I know the ground reality.
because
No.
I was just standing, he was just 2 months lawyer and
That's a valid,
13
valid
January
defense.
26 order, you go and challenge.
that I will challenge, but my, he was
Interfere
was
with the impugned judgment.
tortured badly by the CIA staff, and where he was standing, my lords.
We only clarify that the date of the speaking order is 13 January 2026 and not 27th October 2025
Then
as erroneously recorded.
liberty may be given to challenge that. Liberty may be given to challenge that. Right, I'm.
Learned judge has given you liberty, but liberty against order of 27th October 25,
Yes, my lords.
which does not exist.
Yes.
We have clarified that it is the order of 13 January. You can check.
But my lords, very badly, he was beaten 2 months lawyer. He was at that time, and the CIA staff is misbehaving in Gurugram. My lords, I personally know. They are misbehaving with everybody, just torturing and extorting money.
The order does not require it.
2 months lawyer at that time, his registration was there.
Well, next one.
Please, my lord, I already tendered my resignation, my lords. My lords may have it after 2 weeks, my lord.
Why?
Due to change of government.
Tamil Nadu.
Tamil Nadu.
Oh. Adjourn 2 weeks as paid police, Indira.
Much.
May it please you. Yes, I beg to appear for the petitioner.
The only one issue
there is an
problem is there. It's a
interfere,
2001 tender.
not 2001.
Yes, 2001.
Yes,
It is
period was 2021 to 2027.
Your lordship said
Not
2000.
2000.
NIT was issued in 2001.
No,
When NIT was issued?
2021.
21.
There's no delay on my part.
No. So it's a 6 years old NIT.
Yes,
Yes.
it was challenged in a writ petition. Man.
There's always a clause that the department reserves the right to cancel.
But the department doesn't say that, Manoj. I can understand if the department says.
The contract period is from 2021 to 27.
No, Manoj. It says that your lease will run from the time that the lease is executed. So the 7-year lease will only, it's not been executed.
Well, it has not been executed, so time has not started running. That
Your
is
lordship.
But the court has kept in mind the revenue interest of the government.
Yes.
Discretion has not been exercised in your favor. DBA has upheld the order. Why should we interfere in a discretionary order?
So let me answer that. Two aspects. One is, my lords, there is nothing to show that there is revenue loss. I can understand, my lords,
Being on record means
my lords, with
2021,
respect,
whatever would be the rate.
no, with respect.
And if it is advertised now, 2026.
No, Manoj. Someone has to come to the conclusion that the price of sand has gone up. There is nothing to show that. Point number one. Point number two is, Manoj, the department has never said that please retender. That there is a revenue loss and there is a retender.
Invoke the
Now the
discretionary
third point, Manoj.
Department may not say so.
No,
Because we know how departments function, but it is after all the High Court, which is the guardian of the Constitution. If it has taken a view that interest of the state would be best served if there is a retender, you require very strong reasons to dislodge this.
So may I now, Manoj, state one reason why your lordship should dislodge the reason. Your lordships have repeatedly said judiciary, that judicial review, my lords, in a tender matter is extremely limited. Only on the principle of Wednesbury arbitrary. The finding of the single judge or the finding of the division bench, there is no finding returned that there is Wednesbury arbitrariness. Your lordships have gone to the extent of saying in a tender matter we will only interfere where the arbitrariness, my lords, borders on perversity. I ask myself this question from the division bench order or from the order of the single judge, where is the finding returned that there is any arbitrariness? The High Court...
In tender matters,
Yes, Manoj.
courts have to decide the list, keeping in mind public interest. Even if you make out a solid point on law, the court may refuse to do so.
It may.
Right?
It may, Manoj. Now let me point out.
Maritime, these decisions are there from 2001 on.
Yes. Now let me point out, Manoj.
Court may not have referred to those decisions.
Yes.
But the essence of the judgment is this, that this would not be in furtherance of public interest to allow this 2021 tender to proceed.
Manoj,
That is the point.
Yes. Now may I answer that? I can understand, Manoj, as I said so at the outset. I can understand, my lords, if the court came to the conclusion that there was a substantial price escalation. There is no data before the court to come to this particular conclusion either. Now, otherwise, my lords, the principle is fairly hazardous, my lords, so far as the citizen is concerned. Your lordships have, my lords, starting from Antule's case, said that act of court should do no wrong. That is, my lords, no party should suffer on account of the fact that the list remains pending before the court. There is no portion of the blame which is apportioned to me for the delay, my lords, in this particular aspect. In which case, my lords, I, who is the highest bidder, who has bid substantially over the reserve price, is put to prejudice for no fault of my own. I can understand, my lords, if the court had said that there is a 40% price escalation, there is a 50% price escalation, or there is a 10% price escalation. There is no such finding which is returned. And please see the judgment of the division bench, my lords. The division bench effectively exercising jurisdiction under LPA, that's, my lords, effectively the first appeal against the single judge. There's nothing dealt with by the division bench. It's only, my lords, just one particular line which says that if the single judge has done this, we don't interfere, almost as if it's a 136 discretion. At least in an LPA, something should have been dealt with by the learned division bench. That's my respectful submission.
With
Otherwise,
regard to the decisions of this court in so-and-so versus so-and-so and so-and-so versus so-and-so, we see no reason to interfere.
your lordship's discretion, my lords, I can't put it about that.
That is why we are referring to Cochin International and Air India.
Lordship.
These
In
two
fact, your
decisions, we will
lordships,
give the citation.
your lordships took a view, my lords, in Adani port,
Yes.
which I wanted to rely upon.
Right. So that was there.
That was
Not
there.
here.
I think it will pervade here as well. Lordship, please.
May I please, my lords? My lords, concurrent findings, my lords, in my favor, my lords. Grateful, my lords. My lords, stay as well, my lords. My lords, because I've been directed to allot a plot at 120 rupees per square yard, my lord.
Notice and stay.
Grateful.
My lord, in this matter, only issue is before my lord is that the married daughter is a dependent.
What about the love, affection, care of the mother towards the married daughters?
My lord,
As soon as the mother dies,
right, my lord.
they would be deprived of love, care, affection of their mother. So that is why they have been given 40,000 into and 40,000.
That has been given, my lord. But the dependency, they have given 32 lakhs more. 32 lakhs
more.
More, my lord.
About 32 lakh more. I come to page B.
My lord.
Come to page B. Where do we get this 62,000 figure, sir?
Page B, my lord.
Page B. You are proceeding absolutely on an erroneous basis, subject to we being corrected.
My lord.
That from 29 lakh, it has been raised to 62 lakh. Sorry.
My lord,
29 lakh has been increased to 32 lakh.
My lord, they have claimed 89 lakh. The tribunal has given 29 lakh 80,000 and the High Court has enhanced 32.
Please come to 23.
23, my lord. My lord.
Come to the table.
My lord.
Table shows amount claim.
My lord.
Amount awarded.
My lord.
Enhanced compensation.
My lord.
Enhanced compensation is 32, 44, 514.
Instead of, my lord, 2796.
That accordingly the applicants are entitled to get.
My lord, because the title has been given enhanced compensation. It is enhanced 32 lakh more, my lord.
Your SLP should have been dismissed on the ground of 500 days delay.
My lord, that's true.
Right? But we are looked into the matter on merit.
Value.
Dismissed. Password.
The main petition is pending.
नहीं है password. है.
My lord, I am seeking passover in this matter.
Your lordship, there is a letter any day in the next week, maybe.
Who has asked for adjournment?
Respondent. Petitioner.
No, petitioner, my lord.
Petitioner has asked for adjournment.
Yes, your lordship. Only 1 week adjournment due to personal difficulty of senior counsel. Only 1 week. Any day in the next week.
After vacation.
Please.
After vacation.
Your lordship, I'm requesting for a short accommodation in this matter.
See,
Wait, please, my lords. My lords, the conviction.
He's in
and-
jail or how?
He's still in jail, my lords. 5 years and 6 months, 7 years is the total.
6 months out of 7.
That's right, my lords.
Sir?
Agreement terminated. Matter was before NCLAT, and now this is what your lordship says on the jurisdiction under 60. Lord, that is their right. That is going to be my argument. In case termination is illegal, they could have only gone for damages. I am citing a judgment in support of that proposition. But first, my lord, your lordship may kindly have just this judgment, my lord, and 2 paragraphs of this judgment. I just want to show. This is AA Estate.
What is the fault of these home buyers?
My lord, home buyers will come late, will come at a stage. If your lordship,
Ultimately, they are the people who are suffering.
so my lord, therefore, we have to give 40 crores or minus 10%, 42 minus 10%. Assuming a lordship comes to the conclusion, we have some right and we have a right in the property. We are willing to sit and settle with the home buyers, my lord. There is no problem about that today. But the point is, riding on their back, can we be denied of our rights in the property? My lord, just see this order, my lord. Just see the.
For that, you can file civil suit.
My lord, just see.
For your money.
Before, I will
claim damages.
I will respond to that. Just allow me to show 2 more pages. Your lordship saw page 600. Just allow me to show 2 more pages. Page 600, just 3 paras. Para 8. Kindly have para 8 with me. After hearing the party and perusal of the office record, the following facts emerge. Order dated 9 December passed by my predecessor granting in principle approval regarding assignment so-and-so. Marketing rights. Joint marketing rights were not assigned to PIDPL. Then para 3I. Consent for developer owners has also not been submitted. Further, both power of attorney and agreement executed were revocable, stand terminated in 9 and owners in terms of clause so-and-so, so-and-so. This is the finding he records. They file an appeal against that. At page 602, the appeal is rejected. I will not read that order now. Then they take it to the High Court. Please see what happens in the High Court. At page 770. First have page 694 where the prayers are there. They have withdrawn that writ petition on a statement which is not correct. I am going to show to your lordships. 694 is their writ in the Punjab and Haryana High Court. And this writ is filed, my lord, by the RP. The same person who then comes and makes an application having failed in this process. This is not what insolvency proceedings were meant to be. Please have page 640. The writ petition is filed by the RP. And please see the prayer at page 694. Set aside the impugned order dated 14/7 passed by the additional chief secretary so-and-so, by which the request of the petition was not allowed for joint development in respect of the license. Direct the director town and country planner to transfer the beneficial interest in favor of Paul subject to payment of such fee or charges. Exactly what this order has done now. This order actually has gone a step further and asked us to deliver possession of the land also. Pass any other order. Now this writ comes up for hearing, my lord, at page 770.
Home buyers have paid them money.
Look, the home buyers have paid more than 115 crores in
when?
2016 to the state.
No, that's not correct. That's not correct, my lord.
2008 to 2010, the home buyers.
Yes. From 7th June 2008 up to 10.
Almost 18 to 20.
My lord, home buyers should not hold your lordships back. We as a company realize home buyers have come on the scene. If your lordship settles my dispute with Paul, assuming
for 18 years, their money is.
My lord, so we are not running away from this court, my lord. Your lordship can always see that.
That is why NCLT, that is why the matter has gone to NCLT and the NCLT is taking care of everyone.
No, but my lord, the NCLT has introduced Paul, which was out. If I was the one, just kindly at page 770.
Sorry, my lords. My instructions are from 2007. The home buyers are paying the money. I'm so sorry. I said 2008.
It cannot be. Development rights were conferred only on 15/1/2008. So they can't have paid in 7. My friend is wrong on the face of it. And their own pleading is that the money was the buyer builder agreement is the first agreement is dated 7 June 2008 at page 666. My friend is wrong in his dates, my lord.
I'll show from NCLT record.
Anyway, my lord, this is a side wind. I'm not getting into this debate with him at the moment. So please see page 750, my lord. 770.
Yes.
Now, my lord, it's very interesting. I'll tell your lordship one more thing. The resolution professional, during the course of the proceedings before the NCLT, was asked to file an affidavit that what is the status of the construction. Now, status of the construction will come later. Please see that affidavit is at page 755. Please see what he says at 756, para 4. Please see that. And today he's singing a totally contrary tune. Please see 756, para 4. This is the RP's affidavit. Please see 755. Affidavit on behalf of the resolution professional in compliance of order dated 25th April 2024. 755.
Yes.
This is affidavit on behalf of the resolution professional in compliance of order dated 25th April 2024. Para 4 at 756, next page. It is submitted that the corporate debtor executed an agreement dated 15 January with Triveni Ferrous Infrastructure Limited, Ferrous Alloys for granting development rights, etc. If just come 5 lines below, pertinently the said agreement was cancelled by Maximal Infrastructure Limited since the possession was not being handed over to the RP. The RP filed an IA, etc., etc. He has filed an affidavit that the agreement is cancelled. So, my lord, I am only submitting, my lord, this matter, your lordship may kindly examine in a little more detail. Let them file their counters. Your lordship may look into it, my lord. It's something. Now, please see the jurisdiction. Jurisdictional matter. Just give that A. Double A. Just kindly have para 15 of this judgment. I mean, it completely covers what the point I'm seeking to argue. Just pass over. Please have para 15. And after this,
Which para?
para 15, 1-5.
Yes.
According to the appellants, the termination of the development agreement dated October 16, 2005 and the supplementary agreement dated December 23, 2005 and April 9, 14 by respondent number 1 society was arbitrary, invalid and contrary to the contractual terms. It was contended that once the agreement conferred an exclusive right, I don't need to take your lordships. Now come to para 15.5. So it was a similar case where development agreement terminated. Matter was before NCLAT. And now this is what your lordship says on the jurisdiction under 65(3)(c), para 15.5. In Gujarat Urja Vikas Nigam, this court examined the National Company Law Tribunal's jurisdiction under section 65(c) of the Insolvency and Bankruptcy Code and held that the power to restrain or set aside termination is confined to cases where 1. The termination is solely on account of insolvency, for example, by an ipso facto clause, and such termination would inevitably result in the corporate death of the debtor by depriving it of its sole or central contract essential for the success of corporate insolvency proceedings. The court cautioned that the National Company Law Tribunal must refrain from interfering with valid contractual terminations based on breaches unrelated to insolvency. The following observation is pertinent. Given that the terms used in section 65(c) are of wide import as recognized in a consistent line of authority, we hold that the National Company Law Tribunal was empowered to restrain the appellant from terminating power purchase agreement. Our decision is premised upon a recognition of the centrality of power purchase agreement in the present case for success of the corporate insolvency process, etc. In doing so, if your lordship will come a little below, the jurisdiction, last 2 lines on the page, the jurisdiction of the, before that also, would have been empowered to set aside the termination of power purchase agreement in this case because the termination took place solely on the ground of insolvency. The jurisdiction of National Company Law Tribunal under 65(c) of the code cannot be invoked in matters where termination may take place on grounds unrelated to insolvency of the corporate debtor. Even more crucially, it cannot be invoked in the event of a legitimate termination on an ipso facto clause like Article 19(2)(1), if termination will have the effect of making certain the death of the corporate debtor. As such, in all future cases, the valid contractual terminations which would merely dilute the value and not push it to corporate death, sole contract. Now, next 15.6 is important. The above reasoning was reiterated in Tata Consultancy, where this court held that the national company law's residuary jurisdiction cannot be invoked if the termination of contract arises from deficiencies or defaults independent of insolvency. Intervention is justified only when termination would make certain the corporate death of the debtor. The following paragraph is, the contract in question was terminated by the third party on an ipso facto clause, that is the fact of the insolvency itself constituted an event. Now, if your lordship will see the last 3-4 lines on this para only, the nexus with the insolvency must exist. Thus, the residuary clause cannot be invoked if termination is based on grounds unrelated to the insolvency of the corporate debtor. And then see para 15.7, where your lordships declined to interfere. Applying these principles, the termination in the present case was not occasioned by insolvency of the corporate debtor, but by persistent non-performance. Letters were issued, etc. Last line, thus the termination was based on legitimate grounds unrelated to insolvency. Now, here also this will apply, my lord. This termination is not based on insolvency. This is an unrelated, independent episode. So, my lord, according to me, therefore, the National Company Appellate Tribunal would not have jurisdiction to examine such a termination.
Yes.
So, my lord, and what does the tribunal relies extensively on the order of this court in contempt proceedings and in the settlement proceedings. In the settlement proceedings, first of all, I have shown to your lordship's clause where we have mentioned that the GPA was cancelled. That is specifically recorded in that settlement proceeding. 2, in the settlement proceeding, when two partners are settling, they identify a debt by calling it the dues of Paul. That does not mean that that agreement still subsists. If you want to identify, my original license was divided into 4 parts. For the purpose of identification, and we had 4 different agreements with 4 different people. If for the purpose of identification of that debt, we have referred to Paul as an entity, that does not mean that the agreement subsists. That is central to what the NCLAT holds.
Anything else?
Huh? My lord, one more order, my lord, I'll show to your lordships. Please have page 558. 558. This was an application, my lord, moved by the resolution professional before this court for a direction to the DTCP. 558. Application.
This one and then this. Contempt, same contempt.
7. In the same contempt proceedings, at page 557, in the same contempt proceedings, that is contempt petition number 34 of 2016, the RP had moved an application to make for certain directions to the DTCP to give him development rights, etc., etc. Then your lordship was not inclined to entertain that controversy here, so he withdrew it at page 557. So he withdrew it here. Then he approached the DTCP. The DTCP then dismissed that application. Then he goes to the High Court and withdraws the writ petition, saying that some proceedings are pending before the NCLT, whereas no such proceedings at that time were pending for this purpose before the NCLT. And then he goes to the NCLT and then that NCLT order and the appellate order.
Yes.
May I, my lords? I'm sorry. I appear for the RP, my lords, R1 in this particular matter. My lords, right at the outset, may I take the liberty of handing over one of the orders of this honorable court?
See,
Please, my lords.
yes, it's the point of jurisdiction.
Please.
That requires consideration. So you will hear it finally.
May I respond just very briefly? May I respond to what's falling from your lords? It's just
And a very important issue. And the Justice Party wala's judgment.
my lords, that may I with greatest respect just submit this. My lords, the AA judgment that has been cited before your lordships proceeds on the premise that there is a termination, and the question in that judgment was, is the termination valid or invalid? In this present matter, my lords, what I seek to place before your lordships is that the termination itself, which for the first time this letter suddenly comes up in 24, was not even contemplated. And the reason why I say that, my lords,
In your own application,
yes,
you admitted that the agreement has been terminated.
I appreciate. I saw those lines carefully as well, my lords. My lords, those were said in the context. In fact, if your lordships were to read further down on that as well, in fact, one of the lines was on the basis of the affidavit that I have come to know in 24 that there is a termination letter. It is only in 24 that they filed an affidavit, placed this document on record, and that's what I'm referring to over here. So as an RP, I'm between the devil and the deep blue over here. I'm saying there seems to be a case being set up, which is saying it's terminated, but according to me, it's not a termination. It's not valid in law. So I've not acquiesced to saying that it is a termination. Be that as it may I just take one step back, my lords. I had, my lords, on the day before, I had stated, and there was some controversy, whether a particular order of this honorable court had been placed on record or not. My learned friends had said, no, it is on record. And I, being handicapped, being online, could not controvert that. And it's a relevant order of this honorable court. May I just pass on this order? Please pass on 9/10/2020. In fact, unfortunately, I'll show 6 orders which have not been placed of the Honorable Supreme Court 1, but of DTCP and Haryana RERA, where they go ahead and say, we have no development rights. So when it came to them having to pay, they said, oh, we have no development rights. We have nothing left in our favor. My lords, this is an order dated 9/10/2020 of this Honorable Court. Also referred to in the order, in the impugned judgment. Please have...
I know.
Your lordships would please have... Roman 1, Mittal Group shall apply for renewal of license numbers 34, 35, 36 within a period of 2 weeks. If not applied for renewal, so I'm so sorry. I'm so sorry, my lords.
Lords, I well file my reply. My predicament
In the
is...
meantime, status quo should prevail.
I'll-
In the meantime, status quo should...
Can I request just one thing, my lords? My lords may keep it immediately on reopening on my lords. I'll take more than 15 minutes. I won't not take because I'll just file certain documents they've not brought on record.
File your...
My lords, in fact, what has happened in this matter, after the purported cancellation, development has been done.
Was hearing.
I bow down.
Counter by 28th. May. The first week of June?
Very well.
First week of June.
Yes.
I am not in the country. First week of July, I can come. First week of July is also off.
First week of July, we are not sitting together.
I'm sorry. I have already gone. Not in the country.
Rejoinder by 17th on 22nd July.
Great.
My lords, I had filed an intervention in NCLT and I was heard and my submissions are recorded. They've not made me a party, my lords. So my lords may
We'll
implead.
hear your intervention.
So my lords, can I have the liberty to file a short
Status quo
note?
as on today, my lord.
My lords, with greatest respect, I have to resist this.
Hand over possession, etc. My lord.
My lords,
Where is the prayer?
In the SLP.
In the civil appeal, this is appeal.
Yes. Prayer is there. Prayer is there. Huh? Page 182.
my lords, after much difficulty, the
One-
CIR process is finally
One
restarted.
second, my lord. 1071 is the application for stay. 1071.
1071.
Yes, my lord. Prayer is at page 1071. Grant ex parte ad interim stay of operation of the final judgment and pass any other interim order.
Where is my?
1071.
Where is the direction that you are required?
Yes. Kindly have that direction. At page 61, clause 3B.
61.
The subject land having been held to be asset of the corporate debtor, resolution professional to take control, maintain and protect the. We are in possession and control at the moment. In fact, before the NCLT, he never even wanted possession.
My
I can
lords-
show that page 814.
My lords, they are in forced possession. The possession is in fact otherwise.
The directions in para 54.
My lords,
may I-
may implead me as a party, my lords?
Great.
Associate,
My lords,
so that I can
the
file
cost-
a note in because.
At the cost of troubling your lordships on the stay.
So permitted to file counter.
Very well. I'll give my lords, my associate.
My lords, at the cost of troubling your lordships on the stay aspect. My lords, with a lot of the documents also not having been placed before your lordships over here, and they're seeking an equitable order.
That they are suppressed material documents, they will have it from the court.
My lords, with great difficulty, the CIRP finally restarted, and we are at the process. The Form G has been issued.
Grateful. Great.
Very grateful, my lords.
Your Lordship, I'm taking a Passover.
Passover.
38, please.
Then,
My lord,
this is next week, my lords.
Which one?
This one, 13.
38.
38 lordships.
Lordship, the interim protection to be cut.
No, my lords.
Is there an
One.
interim protection?
My lord, this is a case of anticipatory bail, my lord, in a case.
It's Passover? Come up.
Yes,
There is no interim
Mr.
protection.
Sanjay,
in this
we'll hear
case.
it. We'll hear it today.
Can it be tomorrow, my lords?
Very well, tomorrow.
Tomorrow.
Lordship. And protection to be extended.
No, there's
What
no
protection? There is
at
no
all.
protection.
Order already.
There is no protection. Press
There's-
matter.
30 is
Fresh matter.
tomorrow.
You done?
Lordship, as per the order, we have to surrender this tomorrow. So that's why I'm seeking that.
2 minutes. Don't surrender
will be heard.
tomorrow. First thing in the morning, it will be taken.
Please.
My lord, here your lordship will see there is a conflict between two judgments. Justice Hemant Gupta's judgment in the Punjab and Haryana High Court has not been considered at all. I've got the judgment, my lord.
Mr. Banerjee, this is 31J.
31.
So on the date, the demand notice under 13.2 was issued. What was the due amount?
10 crores and some odd. Out of 50.
So
Out of
was the
50.
demand notice per se invalid on the date it was issued?
We have in our
It
petition
has to
that
be
that is
seen from
invalid.
the date of issuance of the demand notice. It cannot be.
My lord, there is a
What does the law say? This will have no application if J.
no. J is an
is
unconditional term. My lord, if your lordship,
You are going on 31J.
I'm going on 31. J. If your
So
lordship,
on the date of 13.2, 31J must apply.
my lord, even afterwards, if, my lord, in that event, my lord, okay, I understand your lordship's view. May I say this? 13. Let me tell you. Let me lord on the facts, my lord. Your lordship will forget the question of law for the time being.
No, it's a special petition. Unless
But-
you satisfy us on the question of
No,
law,
according to there's a conflict in judgments. My lord, may I just indicate this?
you go and pursue your
My lord,
remedies before
May I indicate one thing? I paid. May I indicate, my lord? Not the law. 41 to 42 crores out of 50 crores I have paid, my lord. I am willing to pay the balance. Your lordship gives me some time deposit 5 to 7 crores.
Go before the.
No, my lordship gives me this liberty. I'll pay the money. Your lordship allows me to pay in 2 weeks. 2 weeks time, my lord. Because the auction is tomorrow, my lord. I can't unless your lordship allows this, my lord. I can't. Your lordship allow me to pay the balance.
Why did you come here?
No, my lord, because of this conflict of judgments, my lord.
Dismiss
No,
with,
my,
liberty to.
my lord, the auction, if then your lordship,
Tribunal
the auction is tomorrow, my lord, how can I will have no remedy left. My lord.
Mr. Banerjee, if the auction is being conducted not in accordance with law, the power of the DRT under 17(3) is quite wide.
No, I'm
You
not
get
saying,
everything back.
I'm only saying this, my lord, that I have paid 42 crores out of 50. I have to pay some 8 or 9 crores. Your lordship will put me to terms. I'll pay that within 2 weeks, my lord.
No. This is the last moment you try to scuttle everything. We will not.
My lord,
permit that.
this is a difference of judgments between the two. The High Court judgment, my lord.
Sorry.
Your lordship will at least give me the liberty to apply for extension before the appropriate forum, my lord, for payment of the balance money. Your lordship gives me that liberty.
We have given you liberty to raise all the contentions before the relevant tribunal.
Very well. I'm obliged.
Next.
Because I apologize for the Passover. Because High Court while commenting,
Petition is pending before the High Court.
because that is what my case is. The High Court practically renders me a mobile vendor despite my cases that I'm a stationary vendor.
Your COV,
Please, Milos.
certificate of vending,
It says others,
no,
Milos.
it does not say others. What is this others?
Milos, what has
What
happened
is
is
this others? The court has explained. Others
Please, Milos.
include
the local vendors.
1.1
Yes.
3 specifies the others category, right?
Milos,
No.
my whole challenge is that I am not in the others category. I am a stationary vendor, Thehbazari holder.
Then what does your COV say?
Milos, the COV is absolutely wrong. That is what my submission is before the learned
You
Honorable
start
High Court.
vending on the basis of this certificate.
No, Milos.
And thereafter you say your COV
I am
is wrong.
vending on the basis of a Thehbazari receipt since 1992. I have a better footing than a COV holder, Milos. I am a permanent Thehbazari holder. So I am saying, Milos, this
Why did you accept this COV?
Milos, because of the survey, everyone has to be surveyed. I am a member of the TVC.
Get it there.
Milos, may at least give me liberty to at least say that this order will not affect the merits of the writ petition, Milos.
We clarify that the impugned order, which declines to initiate proceedings for contempt, shall have no bearing when the petitioner's writ petition is finally taken up.
Deeply obliged.
Yes, Master.
He's ready.
He can pay 15 lakh rupees.
No, don't start bargaining here
I'm
again.
not bargaining.
Look at her. She has to survive.
Yes, no, because
See, you will get married, but
No,
this
no.
poor lady will never get married. Try to understand.
may I
No,
say
no,
that?
so no, let me
Because I've already paid 9 lakh. 9 lakh rupees we've
If
already
you don't agree, we'll dismiss your case.
Then your lordship will have to give me some time. We'll have to spread it.
You wander over it, come back in the first week of August.
What your lordship can do is refer it back to mediation. We can draft it up for 20 lakh rupees and some time that I have to make that payment in.
You make a draft, we'll keep it 7 days later.
I'll do that.
Give a copy to him.
I'll do that.
Right?
Some payment schedule.
No use sending it back to mediation.
I'll pay it.
The sum, she says 20.
20.
Agree to 20, draft it in consultation with your learned friend.
I'll do that.
Get all proceedings quashed. We'll pass the order.
I'm grateful. I'll do that. I'm grateful.
List after 7 days.
I'm grateful.
But this is that
Order 7 rule 11.
Yes, I finished my learned friend has to do.
Yes.
I was in the companion facility. I thought not your option wanted to hear my friends first for my.
On the last day, Mr. Gupta was there.
Yes.
Perhaps Mr. Kumar was not there. But anyway, you start.
Yes, sir.
I'm not be taking the 12 o'clock matter.
What is that?
O'clock matter.
What is that?
120.
120 was for 12 o'clock.
What is the matter about?
Well, that was the matter whether 7-11, a suit can be rejected on the ground of.
So one 7-11 be completed, then another 7-11.
No, my suit has been dismissed here.
This is also a 7-11. Dr. Singhvi's has been dismissed.
No, this was
rejected.
430 of the company.
True.
But excludes the jurisdiction of the civil court.
I don't think in the second half we have a different range.
Yes.
We'll have to keep it for another.
Well, can it remain on board in the same position?
That's all.
For 12 o'clock.
Let us see.
Yeah.
No,
same position
at 12 o'clock.
Huh?
On 2 occasions, Lord, will keep it at 12 o'clock. o'clock, Your Lordship. Let the same position go.
12 बज गया, sir.
My friend has left the court. My lord,
So let us see. Let us see.
Just to retain its possession.
Yes, sir. Yeah.
That's all.
Why I'm making this request, my lord, is
Take date.
We have some different plan for next week also. It could be that if the constitution bench matter is over, Justice Masi will be with me for hearing out the parted matters. Your Raheja is there and some other matters are there. So we can't.
Can we do one thing, my lord? Can it just remain on board for next week in case your lordships are
In
not?
case we are there, we will.
That's right. No.
But take our only request is it be kept for 12 because otherwise it's 120. Number is 120, then continuing on the same position as 120 is no use.
We'll get a clearer picture by tomorrow.
My lords.
Thereafter.
So your lordships are just.
We are not just now saying that it will be there next Tuesday.
And your lordships
If we-
directions to you.
I'm sitting with Justice Masi, definitely this will not be there.
Please not.
There are too many matters which have to be. We will.
Otherwise, if that is the uncertainty, would your lordship want to have it after vacation?
If we are there in the same combination next week, it will
I
be
can
there.
just say with a
Sometime
certain
it
amount of
will be there.
information, I'm in the next batsman in the 9 judges. But I'm going to.
So it will not conclude.
So the Chief Justice made it clear it must conclude by tomorrow. Because of some spillovers, I'm sure it may go for a half a day on Tuesday, but it is 100% going to conclude by Tuesday.
Get over, yes.
The Chief Justice has told us many times, and we know that it's.
Would your lordship then just
Justice.
keep it after vacation, my lord?
If everyone agrees, we'll keep it after vacation.
What is?
20th of July.
11, 12, 15. RCA filed by R4 against the order dated 3/8/15 dismissed by the district judge Nagpur points at such and such.
Training qualification, provided that a teacher who at the commencement of this act, so this is a proviso, does not possess minimum qualifications laid down and shall secure such minimum qualification within a period of 5 years. Then, provided further that every teacher appointed or in position as on 31st March 2015 who does not possess minimum qualification as laid down in subsection 1 shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the Right to Children Free Education Amendment Act 2017. Well, that's what it says. But Malas will then come to what lordships have observed in the.
What do you make of this? Or in position as on 31st March 2015.
Malas will please come to. Malas, I'll just take Malas through that. Malas will please come to the order, Malas. I'm sorry. Will bear with me, Malas. Impugned order. And what we are aggrieved by. Malas, it has page 214. May I please para 214 of the impugned, page 108.
Just tell us the para number.
Para 214.
214. Yes.
For the detailed discussions above and resting on the same, we hold that the provisions of the RTE Act have to be complied with by all schools as defined in 2N of the RTE, or 2N of the RTE, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided and subject to the answers to the question formulated under Section 7. Logically, it would follow that in-service teachers, irrespective of their length of service, would also be required to qualify TET to continue in service. Others will thereafter, will bear with me. However, we are mindful of the ground realities as well as the practical challenges. There are in-service teachers who were recruited, Lordship has obviously recognized that much prior to the advent of RT Act, and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by have not shown in life to dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, though we are alive to the settled legal position that operation of statute can never be seen as an evil. Bearing in mind their predicament, we invoke our Article 142 of the Constitution and direct that those teachers who have less than 5 years of service left may continue in service till they attain the age of superannuation without qualifying the TET. However, we make it clear that if any such teacher having less than aspires for promotion, he will not be considered eligible without having qualified TET. Then, Malas, this is insofar as in-service teachers recruited prior to the enactment of the RTE Act and having more than 5 years to retire on superannuation are concerned, they shall be under an obligation to qualify the TET within 2 years from the date in order to continue in service. In any of such teachers fail to qualify the TET within the time we have allowed, they shall have to quit service. Malas will see the section. The Lordships have said the proviso. This portion, especially which Lordships have indicated, they shall be on an obligation to qualify TET within 2 years. If any such teachers fail to qualify the TET within that time we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever terminal benefits they are entitled to. We add a rider to that, qualify for terminal benefits. Such teachers might have put in qualifying period, obviously with qualifying service. If any teacher has not put in qualifying service, well, it's this compulsory retirement and will not be entitled to continue in service. Well, it's my submission. That is not reflected directly. What Lordships has said, well, I can take my lord through the notifications and what has happened, but this does not reflect in the section as well. What my lord,
the object of the act, Mr. Solicitor?
The object of the act is right to education, so that well, it's obviously everybody gets
for children.
For
children.
For children, no doubt.
To exist for the children.
Yes, my lords. But Lordships
don't be so self-centered.
Not at all, my lords.
That only I will be getting orders from the court protecting my service. There should be security. But we will not think about the children.
No, not at all, my lords. May I?
You have to give some meaning to the second proviso.
May I?
Please give some meaning to the second proviso.
Malas, it has to be read.
The scheme of the act, the statutory scheme was this. Yes. Initially, within 5 years, you have to. The legislature was alive to the challenge that there may not be institutions. That is why relaxation was also there.
Yes.
Right? You did not comply.
Malas,
you did not qualify the examination.
Yes.
Again, in 2017, the second proviso comes in. Why? What is the purpose of the second provision?
Well, what Lordships have also noted at 215 is also extremely important. My lords, the entire basis of what Lordships, my understanding...
balance the interests of all the teachers.
No, my lords have also considered, and I'm saying this, Lordship genuinely also considered.
2017 gives 4 years.
Yes.
But it is with retrospective effect from 15. So you get only 2 years time, 2017 to 2019. In 2025, we are giving another 2 years time.
Yes. Well, I'm not denying it, but
so the teachers will not qualify. The teachers will have the right to continue giving the second proviso a complete go by.
Our submission is this.
Mr. and all other learned counsel, please throw some light how you overcome this second proviso. We have kept it for open hearing only for this purpose.
Fellows will come to the 23rd August
notification. So, sir, it's para 9.
Fellows will please come to the which 23rd August 2000.
We'll have to decide one after the other.
I'm sorry,
not that solicitor is in the midst of his argument. Somebody start.
Malas will please come to the notification.
Take his seat. We'll call upon the next.
Malas will
not like this. Otherwise, there's.
Malas will just bear with me. This was brought into effect by the 23rd August notification, which is page number.
No, this is in the NCT affidavit.
This is in the NCT affidavit, page number 53.
State of UP.
It's part of the NCT affidavit. This is
in the main.
It's not in your review petition, Mr. Solicitor.
I'm sorry.
It's not in your review petition.
It's not. It's quoted. Is it quoted?
No. If it is not there, don't expect us to pick it up from anywhere.
I have
to annexed it to the review petition.
Maybe.
Or you should have all come with a compilation of the statutory provisions and the notifications so that, we don't have to struggle to find it out.
We won, Manoj.
0.31. No, 0.1.
Would I? Very well. You have made your point that this cannot be given retrospective effect.
And Manoj will also see that brought into